What's up, everybody? Welcome back into the episode of The Lawyer You Know. And today we have new updates on Mickey Stines' case and some footage that is additional. People are saying is new footage. I haven't seen it before from inside the judge's chambers that may add a little bit of context to what's going on. But most importantly, something that so many people felt were so sure of what the motive was in this case and what caused the break if something happened and what caused Mickey Stines to potentially shoot a judge for the reasons and with the mindset that the state says he had is completely wrong. It's been denied. We're going to read where we got that information, if we can trust it, if we think some new context is going to come out to give us a motive, or if this all falls in line perfectly, potentially, with Mickey Stines' defense. So hit that like button, get your questions ready. We're about to get into it. So if anybody is not following Brian Entin, Entin's YouTube channel, but you are interested in this case, or Kohberger, because he's still following and posting a lot about Kohberger, he is doing a great job investigating this case, getting more information and putting it out there for the world to take a look at and to see. And we are going to be looking at a video that he did where he has information. He has some of the grand jury transcripts, and he has some information about what's coming out about this motive. We know that there was some shenanigans going on in this judge's chambers. That's why they added a video recording device in there. That's why we have footage of this potentially criminal act, right? We all know he shot the judge, but is it a crime? Which crime is it? All depends on a number of different factors that we're still getting into, because even with a video of him committing this heinous act, he is still presumed innocent. The state still has to prove all of the elements. And we're going to talk about what the mental element is today, specifically in Kentucky, with the charge he's looking at and how some of this new information can really affect that. So a lot of people thought Mickey Stines took a looked at the cell phone, the judge's cell phone, called his daughter right before shooting the judge, and therefore his daughter must have been part of the motive. He said he was worried about his daughter and his wife's safety. And we knew that with the sex ring and all that going on in the civil case and the lawsuits and people getting arrested and the pressure that was on Mickey Stines, everybody took the next logical step to think his daughter or his wife must be involved with the judge. He gets pissed off at the judge. That's what causes him to snap and take the judge's life. Well, there's some reports coming out now that there's evidence against that motive, and that in fact was not the motive. Let's take a listen here. And there's also evidence that potentially Mickey Stines was having a mental break, and they've had to do things like pepper spray him in the jail because of this mental break. Let's take a listen to some of the reporting by Brian Entin, and we're going to focus specifically on how this could affect his legal case.
Also a major focus on Sheriff Stines' mental health during the time of the event and what could have driven him to do that. And I now have the mental health assessment that was done. This came out as part of a new court filing, and I hadn't seen this yet. And this is the mental health assessment that was done shortly after Sheriff Stines was taken to jail. They did an assessment, and it shows that he definitely was not in his right mind. Let me read you some of this here. This is what they wrote in the evaluation form. It says, upon evaluation of Mr. Stines, it appears that he is still in an active state of psychosis.
So this was at the jail. And let me tell you, as a lawyer, a couple things that I pull out of this, okay? I see somebody posting in the chat that Charlie Kirk was shot speaking to a Utah campus today. That's brutal. That's so sad. Anybody on any political side that gets shot giving any speech or doing anything is just continues to be a major problem in our country and something that is brutally sad. So I hope prayers for Charlie Kirk for his recovery. I don't know how serious it is. That sucks all the way around. Man, that really sucks. As I look at this mental health evaluation of Mickey Stines, some of the things that I see that would be important to pick out as an attorney when we know we're dealing with either some kind of diminished capacity or extreme emotional disturbance. In this case, a mental break type of deal. We're going to get into what those definitions are and what you have to prove. But when it says, upon evaluation of Mr. Stines, it appears he is still in an active state of psychosis. So number one, he's in a state of psychosis. And this is pretty close in time to when the act happened, right? But it also says he is still in active state of psychosis, meaning he was before, and they've already made that determination. And I will tell you that every single case that we have ever won with an insanity defense, the state doctors, I shouldn't say every single case because we've gone to trial some, but wherever it gets resolved before trial, the state's doctors agree with our doctors as the defense. So when we're looking at this and we're seeing this as evaluation when he gets to the jail, it seems like some mental health provider that I would call if I was a defense attorney in this case said he was still in an active state of psychosis. And that's going to go a long way when we start reading the definitions of extreme emotional disturbance and how they can really fight this M1 charge that Mickey Stines is looking at and is facing right now. There's another thing that I was thinking, right? We know not everybody gets treated the same way in our justice system, and it's unfair and it's not how it should be, but it is how the world works sometimes. And from my perspective, when we see it to discuss the potential avenues of how we got here, this is an interesting question. Do we think that the jail is trying to do a solid to a cop? Is somebody from the jail making sure this type of information gets into a document that Mickey Stines could use later? I would say no, I don't think so. But I saw somebody ask that question. Do we think Mickey Stines is going to get favorable treatment from other law enforcement entities because he's a sheriff, because he's a cop, especially in this town where, there's a lot of allegations that they're all working together and they're all willing to do things for each other that they wouldn't be willing to do for your common man potentially? So from my perspective, I think it's a fair question. This isn't really written like that. It doesn't seem over the top, but that first sentence is absolutely something I would use in his defense. And this person that wrote this report is somebody I would call into pose to see if potentially they would be one of the state's experts or even one of my experts as somebody who's just a treating professional. I don't know if it's a physician or not, a treating professional for Mickey Stines close in time to when the act was committed. Blazin said, I wish I went to law school instead of nursing. It's great things to be done on both sides. So I'm happy that we have you in the profession that we do. Thank you to Francis for gifting 1 Lawyer You Know membership. And thank you to Sabertooth for gifting 5 Lawyer You Know memberships. All right, let's keep listening.
So they actually said he was in a state of psychosis. He appears disoriented and is only aware of things jail staff tell him. He has no recollection of the recent past. He does not report that he has he does report that he has some paranoia because he is unsure where he is and is told he is incarcerated. So they're saying he didn't even know where he was. He does not appear to understand his charge and is unaware of his surroundings. He denies any suicidal and homicidal ideations. He does present to be responding to internal stimuli during the evaluation. Mr. Stines should continue at high risk level. So they considered him a high risk level when he came into the jail, the sheriff. He has had episodes of combativeness, which has required pepper spray. And that's the first that I've heard of that. I
don't know if he's going to read the rest of it, but I would like to read the rest of it just so we can keep it in our analysis. It is recommended that he be evaluated again within the next 24 hours. Mr. Stines has recently agreed to take risperidone 1 milligram 2 times daily. This began this morning. Will evaluate effectiveness on symptoms when re-triaged. Clearly something going on here with Mickey Stines. And the psychosis is interesting, right? Because we're going to talk about in Kentucky what is necessary, because in certain states with an insanity defense, there has to be some kind of mental defect or mental disease. Kentucky is not one of those states or one of those jurisdictions. But here we are with a document that states this, that I again think is a very big piece of evidence for Mickey Stines in this fight. Mariko said, I accept that he could be psychotic, but why act out at that moment in that office, waiting until he and the judge were alone? So obviously, I don't know the answer to this question, but the defense attorney said all of the stress was building up. The deposition just happened. Things were happening. Things were moving. And that could cause him to go into this psychosis, this mental break where he didn't know what was going on. He has no recollection of the recent past. He has some paranoia. He's unsure where he is. So he doesn't understand his charge. He's unaware of his surroundings. These are all words and verbiage used in insanity type defenses or diminished capacity or extreme emotional disturbance. These are the exact words and verbiage used in defense's arguments. And this isn't a document prepared not by somebody that was a hired expert by the defense. I think that's incredibly important.
Pepper spray. And that's the first that I've heard of that, that they had to use pepper spray on the sheriff when he got to the jail because he was in this state of psychosis. And they say it is recommended that he be evaluated again within the next 24 hours. Mr. Stines has recently agreed to take risperidone, 1 milligram, 2 times daily. This began this morning. We will evaluate effectiveness on symptoms when retriaged. So the takeaway, though, is that they said he's in an active state of psychosis, and it was apparently so bad that they had to pepper spray the sheriff when he actually got to jail. So now the attorney for Sheriff Stines, his defense attorney, has filed this new motion essentially trying to get the indictment thrown out, the grand jury indictment. It was a grand jury that met, which grand jury, of course, is just regular people who meet to decide whether to pursue charges. They get evidence from the prosecution. And the defense attorney, and this is new, is asking for that indictment to be thrown out because he is claiming that this mental health information, partly what I just read you, this evaluation from jail and other things, were not included in the grand jury testimony. When the detective testified to the grand jury, the defense attorney is claiming that a lot of this mental health information was not included and that the grand jury didn't get a good picture of just how disturbed the sheriff actually was. In the motion, it says Detective Clayton Stamper testified to multiple false statements before the Letcher County grand jury. The testimony prejudiced Mr. Stines and resulted in an indictment.
So this is the defense making arguments about some of the witnesses presenting false statements to the grand jury. We heard that in the hearing. We broke down that hearing together, but now we're actually going to get some of the statements that were made to the grand jury, and it's not great. It's not great.
The case was presented to the grand jury approximately 2 months after the defendant's arrest and preliminary hearing. And there's a lot Sheriff Stines' attorney says the detectives knew about Sheriff Stines' diminishing mental health, but they didn't tell the grand jury. Even that the sheriff had talked about a concern that someone was going to kill his wife and daughter and was going to get a bulletproof vest. Again, something new I didn't know. These reports that the sheriff was so paranoid ahead of this shooting with the judge that he even talked about getting a bulletproof vest.
So being so paranoid, right? These are the things I want you to remember, because we're going to draw back on them as we read through the definitions of extreme emotional disturbance, which is what they're going to argue, I believe, in his defense. And what that actually means doesn't mean like in Florida, where if it's an insanity defense, he can go home scot-free. But extreme emotional disturbance, where it comes to he was so paranoid that he got a bulletproof vest. Is that enough? And again, this is going to be up to a jury to decide potentially if all parties don't agree. And you all are like jurors, so we're going to read through and see what you think. Sleuthy said, would that have really stopped them from indicting him, though? And this is a great question. And I'll just tell you, every case, again, that we've had the state agree, which is few and far between, I can think of 2 right now, that we've ever had the state agree without even having a trial. And I think we talked about one. Was it in Florida where the kid that was on some kind of drugs like ate somebody's face and ended their life? I can't remember. It was something like that. And the state agreed that it was an insanity defense and he ended up going to a mental hospital, not prison. So the state does agree. And regardless of whether or not it would have stopped them from indicting him, it can come to a point where the state either in some states agrees to an insanity defense where you're in an institution instead of a prison, and one day you could potentially get out. That's number one. But number two, in a case like this, if the state agrees, maybe M1 goes away and they start to agree that this was some kind of lesser charge that Mickey Stines might plead to that might carry with it a lesser sentence. So that to me is something that could realistically happen.
Something that did not come in during the grand jury testimony. In the grand jury testimony, the detective actually testified that Sheriff Stines was in his right mind. And by the way, when I talk about grand jury testimony, this is normally extremely secret. I don't think
usually you only get it with a court order. Like, hey, give it to them. They have the right to review it. It's the defense. They're going to file this motion, things like that. Very rarely does it get in the hands of reporters.
Any of the cases
or
I've
investigative journalists, is that, I don't know the appropriate term.
Covered, I've ever got my hands on grand jury transcripts. And what's interesting is we have at least a big chunk of the grand jury transcripts in this case because they were released as part of this filing from the defense. And I think what happened is they were released, we got them, a lot of other media got them, and then it seems they quickly realized that, oh shoot, we accidentally released the grand jury transcripts and they've taken them off the website from what I can tell, but they've been reported on now. I've now got my hands on them. And so we've actually got the transcripts of what was said during the grand jury testimony. And that's how we know that a lot of this mental health information was left out, that the grand jury, they had questions, by the way, but that a lot of their questions went unanswered, that they did not include.
And law enforcement simply said he was in his right mind. So obviously the defense is going to argue differently about that, but that's not what happened. And that's not what came out during the grand jury proceeding.
A lot of the information that they had about Sheriff Stines' mental health in the grand jury proceedings. The grand jurors asked for all of Stines' medical records, and they were only read a snippet from the doctor that he saw the day before the shooting, which did not include the doctor's diagnosis. And additionally, the grand jurors specifically subpoenaed.
He saw a doctor the day before the shooting. Is that what they just said? I believe that's what they just said. That he saw a doctor the day before the shooting. Huh. I mean, I'd love to see those records. Those records are definitely going to be part of the trial.
He needed all of Mickey Stines' health records from the jail, and were not given them prior to or during the grand jury proceedings, from what we can tell from the transcripts. Also, there's some new clarity on another issue that came up. Really, a rumor that's
Sleuthy said, "What kind of doctor?" That's pretty important. What kind of doctor? All right, before we get into kind of part two, let me hit some of these questions because they're all on the same topic. Maria, juror number 6 did an interview with STS and said serving as a juror caused him to change his studies to go to law school. That's awesome. Ms. Vicky said, sent you a message on Instagram. Juror number 6 is changing his major to pre-law because of his juror experience. Very cool. That's funny. There's another Adelson juror interview out. 25-year-old says trial made him switch to pre-law. Wants to go to FSU. Great minds think alike here. I don't know what duh juror means. Oh, Donna Adelson juror. I thought you meant like duh juror. That's really funny. I have not seen that interview. I will have to check it out. Sleuthy said like a podiatrist, chiropractor, neurosurgeon. Yeah, I mean, or psychologist, psychiatrist. Who knows? So how does the judge fit into paranoia? Again, if he thinks this judge is going to do something to him, or he felt like he was in danger from this judge and he responded, even though he was wrong, right? Even though he was wrong about that, that can come into the analysis that we're going to get to. Should I do that now or should we finish the rest of this video? Let's hit this now. Since we're hitting this topic. So let me pull up the statute here so we can read it together. And if you can't read it, don't worry. I'm going to read the whole thing. Okay. This is the M statute in Kentucky. A person is guilty of M when, with intent to cause the death of another person, he causes the death of such person or of a third person. So we don't need to get into transferred intent, but except, okay. So if you intend to cause the death and you do cause the death of the person you intend or somebody else, except meaning You're not going to be in the M category, that in any prosecution, a person shall not be guilty under this subsection. Just, all confusing double negatives, but you're not guilty under this subsection if he acted under the influence of extreme emotional disturbance for which there was a reasonable explanation or excuse, the reasonableness of which is to be determined from the viewpoint of a person in the defendant's situation under the circumstances as the defendant believed them to be. So it's a reasonable person standard, which seems and feels objective, right? Reasonable person seems objective, but it's actually subjective, meaning from the defendant's point of view, from the defendant's eyes, from the defendant's thoughts, with the information the defendant has. So the information Mickey Stines had in this case is going to be incredibly important. And when we're dealing with somebody who believes that something's going to happen, they're paranoid, it gets to the level of what's going to make them do this, right? What is going to cause them to snap? And would a reasonable person with the information Mickey Stines had in the position that Mickey Stines was in, would this cause them to snap? That's the real question. An extreme emotional disturbance in Kentucky is a temporary state of mind triggered by a reasonably explained. So how are they going to explain what was going on and whether or not it was reasonable? Well, it's going to be the deposition. It's going to be the sex ring. It's going to be the stuff happening in the sheriff's office. It's going to be the walls closing in on him. Is he next? Is he going to get arrested? All of these things. Triggered by a reasonably explained or excused overwhelming situation. Overwhelming situation. Do you think Mickey Stines, and I'm just asking you guys as jurors, if this was before you and the judge is reading you this language, from what you know, right? There's so much that we don't know. How do we get to somebody that is in a temporary state of mind triggered by a reasonably explained or excused overwhelming situation, viewed from the defendant's perspective, where the defendant has an intense emotional reaction causing a loss of self-control? This disturbance must, and this is another confusing language. It says this disturbance must not be caused by a mental disease or defect equivalent to insanity. It doesn't mean that that the mental disease can't be there. It just means in a lot of states, you have to have a mental disease or defect. That is not something you have to have in Kentucky. By the way, I'm reading this off of another sheet while the M statute is up because I want to keep reading the statute here. Okay, so now let's get back to the statute. So that's extreme emotional disturbance, and you have to explain it from a reasonable person standard in Mickey Stines' shoes and situation. However, and here's the big however, we're reading the second part of this statute or this paragraph. However, nothing contained in this section shall constitute a defense. So that extreme emotional disturbance is a defense to first degree M, but it shall not constitute a defense to a prosecution for or preclude a conviction of manslaughter in the first degree or any other crime. So what that means is this extreme emotional disturbance, if we get there, if we can prove it with the reasonable person standard for somebody that's in Mickey Stines' situation, if we can get there, it is a defense and could win them against a charge of M, but not manslaughter. And that's why, to me, it reads a little bit weaker than a lot of other insanity defenses. And I think that's because it's not a complete bar. I think you'd have to prove more, and the bar would be higher. Like potentially you have to have a mental disease or a defect in order to get to an insanity defense, because that bar has to be higher. And we're going to put you in an institution and, try to help you get back to being a contributing member of society. And then you get released, where if you actually got convicted of the crime and you had the appropriate criminal mindset and intent, you'd be in prison for the rest of your life, potentially. So that's why I think this one feels a little bit weaker, because it's the extreme emotional disturbance, partial defense to first degree M that gets you down to manslaughter. It doesn't get you off scot-free I say scot-free. Some people can be institutionalized for the rest of their life, but I think you know what I mean, a complete defense. Nina said, I read that being sentenced to a mental health institution is worse than prison. How do you figure out what's better for your client? Honestly, I don't know any client that wouldn't prefer an insanity defense, even if they're going to get institutionalized. And I've heard mixed reviews. Nobody says it's amazing or it's great, but one of our clients was out in a relatively short period of time. You know, it's all relative, but to what he was facing if he would have been convicted. Joanne, Peter, I saw a video when this first happened and he was waiting in the hallway and he was paranoid that his fellow officers would shoot him. Yeah, we broke down that video. And I agree. If he was faking paranoia, he did a pretty good job because he seemed very paranoid and it made no sense. And the cops were like, dude, what are you talking about? You've known us your entire life. Sleuthy says, aren't we always told that we shouldn't, or we don't know and shouldn't judge how someone should/would react in a traumatic or overwhelming situation? Seems to only not apply to criminal defendants. Yeah, that is funny. It's kind of like only God can judge me, or don't judge other people. It's like, except when you're on a jury. Risperidone is used for people with aggressive dementia. I know because I have given it to clients. Yeah, I mean, I don't know all the ins and outs, but I know that is something that we study and we bring up. Like, why would a mental health professional prescribe this medication? What does that indicate is going on with this criminal defendant? That's important. Rebecca, we need to talk about mental health in this country. It's sad. Yeah, and it can lead to all sorts of things, maybe even this case. Maybe this judge is a victim of a mental health crisis as well. If he was under extreme emotional distress and mental disease, wouldn't it be his responsibility to recuse himself from the sheriff position? This is a situation where you know that you're under that extreme emotional disturbance or that you have a mental disease or defect. A lot of people don't know or don't admit it, or, you know, those types of things are all important as well. So just because he's using that defense now doesn't mean that he knew it prior. Attorney Larry Foreman, hey, that's my state. Yeah, this extreme emotional disturbance is very different than how we do it with a insanity defense in Florida. I find it very interesting. Yeah, it's in Kentucky. Very interesting. Okay, let's get back to that Entin video now for kind of part two, which is, you know, everybody was so sure about this motive, and I get it because it made sense. But now that we've heard some of the grand jury testimony, assuming it's true, because I think we know some of what was said in the grand jury was not true, and whether it crossed the line of testifying as somebody's opinion that he was of, you know, sound mind at that point. Like, I don't know why a cop would be able to testify to that, but he did. So where do the lines cross? So I don't know, but now we're going to get some information on that motive. Why did Mickey Stines do this? People thought they knew. Let's listen here.
Started on another issue that came up, really a rumor that started shortly after the sheriff shot and killed the judge. And it's sort of still been circulating about whether the judge had some kind of communication with the sheriff's daughter or the sheriff's wife, and whether that could have something to do with the motive. And apparently that is not true. We reported early on that it seemed just like a rumor, but now there is more information from the grand jury testimony that this was just a rumor. You remember shortly after Sheriff Stines shot Judge Mullins to death, he was seen on video talking with Mullins and then using Judge Mullins' phone to make a call. And it was later revealed that the call had been to his daughter, whom the sheriff had failed to reach earlier after calling on his own cell phone. What's interesting is he used the judge's cell phone, and you can see this on video. He takes the judge's cell phone and he used the judge's cell phone to call his daughter. At a preliminary hearing before the grand jury proceedings, Detective Stamper testified about this. And I'm going to read you this part of the grand jury transcript. And again, it's so rare for us to have these transcripts. But
so this is coming from the grand jury transcripts. Now, listen to it, because you guys have watched enough trials by now, okay, to know that it doesn't always come out the same once we get to trial. So I understand people that are going to say that and may still think this has something to do with it. But let's take a listen.
They were released publicly. This part specifically talks about that rumor, again, that was circulating, that perhaps something between the judge and the sheriff's daughter may have caused all of this. So basically, the prosecutor asks, and this is again in front of the grand jury, to the detective, Detective Stamper, throughout your investigation, have you become aware of some speculation in the community involving Judge Mullins and the daughter of Sean Stines? And the
So who was being asked this question? The law enforcement officer. That's who's being asked this question.
detective says, I have. And what is Sean Stines' daughter's name? And then they give the name, which I'm not going to give. How old? 17, I think, or 16. She's in high school. Okay, I'm not sure. She's a juvenile. Has she been interviewed? And they say she has. And was she specifically asked about the speculation in the community? And they say she was. And what was her response? She denied any allegations of having any contact whatsoever with Judge Mullins.
So this is coming secondhand from the officer who said he interviewed Stines' daughter. Okay. Could be absolutely true. Could be straight down the middle. But I will think back to other cases, whether it's Murdoch or whether it's Karen Reed, where things that were said that either were in police reports from interviews that weren't recorded, or that a cop said somebody said somebody different, or somebody said that something wasn't true. Because a bunch of people have been telling me that, like, just because the cop said it doesn't necessarily mean it's true. Okay, sure. We can say that about anything. So we'll leave that open for discussion. But at this point, there is record evidence from the grand jury proceeding that it had nothing to do with Mickey Stines' daughter or wife. So again, how does this fit into that extreme emotional disturbance? How does this fit into Mickey Stines potentially being delusional and paranoid? Because if the daughter and wife really had nothing to do with it, no contact with the judge, and if that is the truth, then Mickey Stines calling his daughter and then snapping right after and doing this, does that add to the fact that, or add to the defense or the argument that he was delusional? His mind was not straight. He called his daughter because he thought the judge was involved in his daughter, and clearly the judge was not. Again, I'm just making that part up for argument's sake. As a defense attorney, it's like, this was very clear. Mickey Stines had snapped. He was not in his right mind. He did not know right from wrong. He was paranoid. He felt like he was protecting himself, protecting his daughter, protecting his wife. So from my perspective, this opens up a can of worms for this extreme emotional disturbance or this mental capacity defense that the defense seems to be running with in this case. That it kind of is in line if, this rumor is completely unfounded, but the reason people ran with this is because he, in fact, used the judge's phone to call his daughter, which is very weird and doesn't make sense. And if it's not a motive, maybe it's evidence of delusion.
This is the daughter. And by contact, what do you mean? By social media, by text, by phone, in person, any kind of contact whatsoever. She denied it. Did she deny any sort of relationship? Yes. That was all just a rumor. This is what the detective is saying. Okay, did you ask the wife of Sean Stines about this? Yes, she was asked the same questions. There were also rumors about her having some kind of relationship with Judge Mullins, and she denied those allegations. Was she specifically asked about whether or not she had any knowledge of her daughter and Judge Mullins having any sort of relationship? Yes, the detective said. And what was her response to that? That was not true. Okay, now as part of your investigation, did you become aware of the daughter's phone number? I did. And did you also obtain and examine Judge Mullins' cell phone? I did. Did you also obtain and examine Judge Mullins' phone records for the cell phone? Yes. Based upon your review of those records thus far and the phones thus far, does there appear to be any communication between Judge Mullins' phone and the daughter's phone? And then they say none whatsoever. Was there a call between the two of those numbers on September 19th, 2024, between the daughter's number and Judge Mullins' number on the day of the shooting? And they say there was. Okay, and based on your investigation, were you able to determine the source of the call? Yes, Sheriff Stines used Judge Mullins' phone while he's sitting in the chair in front of Judge Mullins' desk to call his own daughter. So there was a call from the judge's phone to the sheriff's daughter, but it was the sheriff making that call using the judge's phone. Was her phone number stored in the judge's phone? It was not. Is there any way to retrieve any of it, anything deleted off the phone? Yes, there's ways. What about social media like Snapchat and the other types? There's no evidence.
So it's not just somebody saying something, but they also did the phone download and did not find any connection. I think that's pretty strong evidence. Rebecca said, I want to say this once and not repeat it. It is so very important to remember that there has to be a good mental health backup when you're on medication. One on its own is not enough. I feel very strongly about mental health. Thank you, Peter, for the platform. Yeah, I mean, I am no mental health expert at all, but I know it's a problem. And I know that we have to deal with it. And the way that we currently deal with it, there's a lot of shortcomings to it, at least in certain scenarios. So I'm all for promoting better mental health awareness, dealing with it, getting rid of stigmas, because it's really, really important. Really, really important.
Detective says, is that traceable? Yes, it's traceable. There's no any evidence of any kind of communication with them. And then a juror asks, with the comment you made earlier that one of the deputies said they were trying to steal the family, what was the cause of that? And then the prosecutor says, I guess so in the interviews with the daughter and wife, sorry, some of this is confusing with the transcript. Were there any concerns about their own personal safety? And then the answer is no. So the detective is saying no.
First off, now that I will say, they might not know what Mickey Stines knows, right? Like a guy in his position, it seemed like he was involved in that ring that was going on with all those horrible and deplorable things. The second half of this, if you want to see Brian Entin, he interviews somebody that was involved in all of that with the judge and the cops and how horrible it is, all of them covering up and using their power to do the worst things you can think to people, making people feel horrible, taking advantage of people in vulnerable positions. So I'm pretty sure, I shouldn't say I'm pretty sure because I actually don't know. I don't know if Mickey Stines' wife and daughter knew exactly what Mickey Stines was involved in or what Mickey Stines knew. And I think it's important to keep that in mind when you're asking somebody a question. Like if I have a whole secret life and I'm running some Ponzi scheme, probably not going to talk to my wife about it. And if I don't, and you ask her, she can be like, no, he wasn't doing that. Doesn't mean I wasn't doing that, right? So they don't necessarily know everything. Now, they would know if they had contact with the judge. But if they were in danger, they just might not know. They just might not know. Jen said, more difficult to find a jury for this case? I don't really think so. I mean, I think it's going to be difficult because it's a high-profile case, but I think they'll be able to find a jury for this case.
They did not have concerns about the personal safety. Was there any way to corroborate any sort of statement that they had been kidnapped based on what was being said? And no, they actually did not. So basically here, they're shooting down this rumor, which went rampant in the beginning, that the motive for this shooting was that the sheriff was upset because the judge had some kind of relationship with his daughter.
And that's why we always say, like, just chill, just wait till the evidence comes out. If you want to try to find a motive, that makes sense based on some of the facts. For people to act like that never made any sense, I don't know. I mean, why did he call his daughter? And to me, from my perspective, it's evidence of something, and maybe it's of a delusion. And as the defense, that might be a better argument. Vicky said, then why did Mickey say that they were trying to take his wife and daughter away? Number one, maybe he knew something that nobody else knew. Or number two, maybe it was a delusion and a mental break, exactly what the defense is trying to prove. But this is why we don't jump to conclusions. We don't jump to answers when we don't know the answers, right? We can discuss possibilities. We can discuss what we think the evidence means, inferences from the evidence, all things that jurors do and lawyers do throughout this entire process. But we just have to wait and see how it all develops. And even right now, a lot of the reporting and the grand jury statements and what cops are saying, I don't take that as like Bible, right? I don't take that as like, this is something that I'm going to take to the bank that I can guarantee is true, right? Because again, we've seen it. When they get cross-examined by criminal defense attorneys, sometimes you find out when you shine a light there, that ain't the truth. Let's get to the bottom of it. Let's get to the truth. Not just what makes sense or what we think or what seems easy or what a prosecutor tells us or even what a judge says or a cop says, right? We have to wait and see all the evidence, all the questions, everything scrutinized, and then we can come to the truth, hopefully. I wonder if someone in a psychosis would shoot only once or several times. Statistics. He shot the judge several times and made clear he was, I don't know, but my guess is they have somebody who's done this research. That would be my guess.
His daughter now and his wife are both saying that is not true. That has come out crystal clear in this new grand jury testimony. So if you remember, Sheriff...
And so what else I'll say is good. I'm glad that's not true. I'm glad they're not involved. I'm glad they're not also victims of this judge. I'm very glad to hear that.
Stines walked into the judge's chambers and asked all the other folks in the chambers to leave. This was all on video so that he could have a private word with the judge. And the interaction, there's this surveillance camera so you can see it. But this is important. The video had no sound. And the reason there was video in the judge's chambers, a lot of people have asked me that. Is it normal for there to be surveillance cameras in the judge's chambers?
So this one's jumping around. There's another like 2-minute clip that kind of shows the time and space awareness of like, or context, time and spatial context about like where the people were when he walked in. He kind of walks in and out. We're going to watch that afterwards. It's from a different news channel that just kind of clipped together the 2 minutes there.
How did we get this video? The reason that there is video is because they, by the way, it's not normally allowed under Kentucky late law, but there was this federal civil lawsuit that was filed by an inmate in the Letcher County Jail saying that she was forced to have sex with a sheriff's deputy in Judge Mullins' chambers or would have to go to jail. And she had sex because she wanted to stay on home arrest and to go to drug rehab. And following the filing of that lawsuit, there was this deputy, Ben Fields, who was arrested for rape. I know there's so much here, by the way. I know there's so much to this story and there's so many layers, but just bear with me. The deputy was arrested, Ben Fields, for rape, having sex with the inmate in the judge's chambers, who was unable to consent. And Fields was convicted of rape 3, served almost 6 months in jail. And
so that's the context of the ring that we were talking about. And again, he interviewed somebody involved in that. And kind of the second half of this is dealing with that. All right, let me bring up this other video. It's a quick one. And just to get, I thought it was kind of an interesting spatial awareness thing.
That's right, Casey. This new video shows the minutes leading up to the death of District Judge Kevin Mullins, including Sheriff Mickey Stines asking for Mullins' phone. I was also able to get some insight from a former prosecutor, now defense attorney Tim Horn. Take a look. Surveillance footage from inside of Mullins' chamber shows the judge speaking with a group of people back on September 19th. According to the video's timestamp, Stines enters the judge's chambers at 2:39 p.m. Within the minute, the room clears, leaving the pair alone. For nearly 10 minutes, Stines and Mullins seem to be having a normal conversation, but with no audio in the footage, we don't know what they talked about. At around 2:48, Stines makes a video call to an individual, and then again 1 minute later. It looks like the second call does not go through. Then Stines appears to ask for Mullins' phone while looking at a contact on his own phone. Stines then unlocks Mullins' phone and makes a call. That's when things change. Stines gets up from his chair, reaches for his gun, and fires multiple times. I spoke with former prosecutor, now defense attorney Tim Horn. He spoke from both perspectives after watching the video.
I noticed that the sheriff got up, he locked the door. I think that's a very key moment as a former prosecutor, what's important to me, because he's keeping that judge there and he's not allowing anyone else to come in.
So what does that prove about his mental state, right? That in the video you can get up and see he's locking the door, which to me, I like it. I think that's a good argument, right? He gets up and locks the door. Does he know what's going on? Does he look like he's in a mental state or extreme emotional disturbance? Because the jury's going to be able to see this video. And if you're a prosecutor, you can say, use your common sense, use your own eyes. Does that seem like a guy that's extremely emotionally disturbed, or did you just come up with this defense afterwards to try to get off this charge?
Also asked Horn about the defense's possibility to plead insanity.
I think there's, a partial plausible explanation of diminished capacity. But as a defense lawyer, I'm also thinking that he had an opportunity to walk away. He didn't. He closed the door.
But Horn says without audio in the video, there are still questions that need to be answered.
Yeah, I see people saying lip readers. I've never seen that work. I don't know if that would scientifically be approved or if a judge would allow you to put something like that in, like if that would pass the Daubert scale, basically. But that would be really interesting. Jenny said, does the EED theory put a burden on the defense? It's a good question. It says, I've never done it in Kentucky. There's a couple different ways that it can be handled. Either it's an affirmative defense that the defense has to prove. My guess is it's not that, because it's not an affirmative defense like insanity in Florida. And then the other way is there's two other ways. Either number one, The state would have to prove beyond a reasonable doubt that it was an extreme emotional distress. I would guess, and again, I could be wrong. I'll do some research on this and we can talk about it again next time we talk about this video. But my guess would be the state has to prove the case beyond a reasonable doubt that it was an M. And then the defense can present some kind of evidence of extreme emotional disturbance, to which the jury now has to decide if this was extreme emotional disturbance, then it's manslaughter and not M. If it's not, then it's M. But in rebuttal, then the state can probably come back and respond with arguments of why it was not extreme emotional disturbance beyond a reasonable doubt to help them prove it the whole way through. So it's almost like burden shifting. So first, the state just has to prove the charge. The defense has to bring some evidence of extreme emotional disturbance. Then the state can come and rebut that evidence. That's my guess, just logically thinking of how it works in, other jurisdictions and how other defenses are done. But again, I'm not positive about how exactly it works in Kentucky with this. I can do some research and we can talk about that more on a future video. Okay, I wanted to end with this because another person put up here that Charlie Kirk was shot in Utah, shooter in custody. And yet we've seen this a couple times. I mentioned it already in the beginning. It's, very distracting, very sad. This is going to be something that's going to grab all of our attention, as it should. Anybody on either side of the political aisle that has this done to them should be condemned by everybody on every side of every political aisle. We should want open discussion. We should want diversity of thought. We should be able to learn from each other. I know it doesn't always feel like that. I know this feels like it's more divisive than ever. And I would be praying for or sending prayers for somebody on either side of the political aisle, or a non-political person that this happened to, right? It's brutal. It's not the way it should be done. Nobody should want to take control of culture, politics, agendas, or anything in this way. And I think it's important to find things, because here's what I think. I think, I don't like to talk about politics on this, but I think, news organizations, mainstream media, the people in control want us to be divided, want us to be divided, don't want us to come together for things that we can agree on. And I think we all need to look for more things that we can agree on, because I think we as a society and as a country agree on a lot more than we think we do, because they like to focus on hot button topics where they find things we disagree with and make it the most important thing in the world, where even that nuance is like, okay, I understand where you're coming from. I still disagree. We can still be friends. We can still love each other. Everything can be fine, even though we disagree on this. But when it turns to something like this, that's where we all lose, in my opinion. That's where we all lose, no matter what you believe and what you think. You celebrate this, you're part of the problem, my opinion. But okay, I appreciate you guys coming. I'm going to go check out what's going on with Charlie Kirk and try to catch up with that. You guys are the best. As always, love hanging out with you. Make sure you hit that like button. Make sure you're subscribed. I'll catch you guys on the next one. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast, featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.